Good afternoon, everybody. We'll just give a couple of minutes for folks to join. We do have quite a few registrants for this one. Must be a very, and we know it is a very interesting topic. See the numbers just climbing participants, so it's great to see the interest in this session. Well, in the interest of time, maybe I'll just get started with some of the introductions. My name is Jeff Rempel with the International Association for Impact Assessment, Western and Northern Canada. IAIA is the acronym that we use. So to give a bit of an overview, IAIA is the world's leading professional association in the field of impact assessment. And IAI-WNC, Western Northern Canada affiliate, which is the board that's putting on this session today, is a dynamic and professional organization that includes members of various levels of government, consultants, industry, and NGOs. We provide a wide range of EIA-related activities, including guest speakers, conferences, newsletters, networking opportunities, and much more. That is, for example, some recent sessions that we've had. For one that's going on right now is called More Effective Impact Assessment, Stronger Argument and Clearer Writing, and that's offered by Dr. Glenn Brown. That has 4 sessions that are going on this week and next. We also have another session that we've just put on our Eventbrite called Effective Writing for Impact Assessment, and that's being provided by Wordsmith. That's 3 3-hour sessions starting in January of 2026, so look out for that one. And then events like today's panel discussion with some follow-up in-person sessions, including one that will be hosted in Victoria tonight. So please look out for that. Thank you for your attendance today. I'll start things off with an acknowledgement from the IAWNC board. We acknowledge that the lands where we live and work across Western and Northern Canada, these lands are home to many diverse First Nations, Métis, and Inuit people. And further to that, we acknowledge that our ability to live and work on these lands today is a direct benefit of the policies of expulsion and assimilation of Indigenous peoples during the time of settlement and confederation, and since. We both respect and affirm the rights of all Indigenous people across these lands. So Chris Joseph will be moderating the session today. I'll turn things over to him to do introductions in a moment. Just from a logistics perspective, you'll see in the tools panel at the bottom of the Zoom webinar, there is a question and answer feature. I believe the chat feature is disabled, so you can put your questions into the Q&A feature. You can do that anytime during the panel session, and you can also upvote those questions that you agree with and you would like to see voted up to be answered in priority. And then towards the end of the session, if you want to raise your hand and ask a question verbally, I can take you off mute and we can do that. So with that, I'll pass it on to Chris to introduce our panelists.
Hey, everybody. Yeah, I'm Chris Joseph. I'm a consultant out on the West Coast, and delighted we've got three speakers today. We've got an academic, we've got a private lawyer, and we've got someone from the federal government. I'm going to share my screen, and we'll get things going here. All right, can I get someone to confirm that I've got my screen?
Yeah, we can see it.
Great. Okay. So yeah, we've got Martin Olszynski, Sharon Singh, and Thomas. Now, I think we're still missing Sharon. We've got confirmation, but hopefully she'll pop up shortly. All right, so just a little bit of brief context for me. You know, I went and had a look at what the federal government's saying, and you know, I found this set of statements on a website from September, and it says a lot of great things about what all this fast tracking is supposed to do. But it raises a lot of topics, a lot of questions. You know, it talks about speed. So fast tracking is about getting to development fast. Another way to put this, if we're thinking optimistically, is efficiency. But can the process be fast enough to do what everything people want it to do? And what about when the project's approved? Will development likewise be fast? Talking about decisive action and being clear and predictable. So is it going to be, is there enough clarity? Does this mean that approval is assured, or, how is this all going to pan out? And then it's talking about trading relationships, unlocking new markets, growing our economy, prosperity. So obviously there's so much talk these days about the economy, especially in the face of what's going on with the states. So can this new process that we're supposed to be having, will it translate into actual economic development? Many critics will argue that that's what the IA process has been doing. It's been frustrating that. But recall our last speaker, if you're here in June, we had Rosemary Collard from UBC, and she argued that, it's not so much the regulatory process, but it's business decisions of proponents. So with a few questions raised, I'm going to turn it over to Martin, and he's going to give us a more thorough context piece from an academic and a lawyer's point of view. Oh, sorry, and there are three speakers, but there we are. Martin, you let me know what I need to do.
All right, sounds good. You can stay there for a second. Good afternoon, everyone. I'm Martin Olszynski, joining you all from Treaty 7 territory here in Alberta. And I am an associate professor and the current chair in energy resources and sustainability at the University of Calgary Faculty of Law. So I'm going to do a bit of an overview. I think, the idea was that I would sort of like help contextualize the conversation, anchor the conversation in the federal Bill C5 or Building Canada Act, just as essentially to provide a template that we can all riff from in our conversations afterwards. But I want to say that before I do that, we were talking just before everyone else joined. It is sort of interesting. It was becoming apparent over the summer, and then it's become, I think, very apparent now that none of what I'm about to talk about is currently in play, right? So in a sense, everything that's happened so far with respect to the major project office and announcements, these projects being referred to the MPO, none of it has been done under the formal mechanism of the Act in terms of like designating these projects as being in the national interest and then sort of unleashing the machinery of the Act. So everything so far still essentially like the creation of the major project office and everything that they are doing with projects so far could have been done without Bill C5, right? So it's essentially a concierge service that the government has set up to sort of help try to, it looks like, coordinate, maybe secure funding, vibes, setting up, giving good vibes about some of these projects. But none of what I'm discussing, none of this machinery, formal machinery under Bill C5 or the Building Canada Act has actually been applied. And if you read the news and you're following some of what's going on, you may have heard recently, for instance, the CEO of the MPO, Dawn Farrell, suggested that she actually didn't anticipate more than one or two projects being designated fully as being projects in the national interest. So keep that in mind. Everything that we're going to talk about now is still really hypothetical at this stage. And then that may be, and to some extent, maybe that tells us a little bit about what is actually going on here with the Building Canada Act. So as in terms of an overview, the Act's very short. It's not a long piece of legislation, but I think, I'm not going to cover all of it. There are some details and we can get into that during the Q&A. But generally speaking, the key kind of like things that happen, the key sort of elements, the listing of projects in the national interest, the idea that these projects essentially benefit from an early green light. They also then benefit from a single authorization that sort of combines all authorizations into one. And then as part of that, there are some provisions which would appear to make those authorizations difficult to challenge outside of the Indigenous rights context, at least. We're going to talk about some powers that Parliament reserved or essentially delegated to the cabinet to tweak the federal environmental law regime sort of on an ad hoc basis. And then we're going to talk about sort of what happened as this bill made its way through the House, and in particular, some pretty powerful amendments by the House of Commons in the Standing Committee for Transportation. I think it was the House Transportation Committee that at third reading published a report, and as part of that, there were a series of amendments that they introduced. And so we'll see there's a tension. Overall, I'll say that there's a tension in this bill. There's a lot of sort of like centralizing of power into the executive branch, to cabinet, the prime minister and ministers. But then, efforts were made, and we were in a minority situation. We still are. And so it's interesting to see that, the opposition parties were able to sort of like encumber this process somewhat. And where it all landed and how that works out is something that we can obviously discuss later. So next slide, Chris. So in terms of listing, I think the key thing to understand here is that, yes, there are these criteria. They are referenced at subsection 4 or 5, strengthening Canada's autonomy, resilience, economic benefits, likelihood of success or execution, advancing the interests of Indigenous peoples, contributing to clean growth. The key thing to understand, though, is that this is a non-exhaustive list. These are essentially examples of factors. A strict reading of this provision says that one of them can be present, maybe all of them can be present, two might be present, maybe some other list, right? Like there may be, it can include things that are not referenced here. So it's a very open process. It's essentially very much a cabinet discretionary decision that cabinet can make here in terms of listing projects. It has been encumbered in the original version. Before listing a project in national interest, the minister must consult with affected Indigenous peoples. So that was there. And that's, an attempt to try to reconcile that reality of Section 35 rights and understanding that when these projects are listed this way, that it does create a bit of a fast lane for them, and that we want to make sure that Indigenous rights are considered still. And then again, this provision that I'll come back to later, this that was introduced by the Bloc, and it's an amendment which requires essentially consultation with the province in which, or the territory in which the project will be carried out. But also this consent requirement, which we're having some interesting debates, within the academy here, and I'm sure between private lawyers in terms of just how far this written consent is. What does it mean for projects potentially like interprovincial pipelines, for instance? Does BC have to consent to that? So we can talk about that later for sure. Next slide. So if a project is listed, it benefits from what's called this early green light that we've been referring to. And essentially what Section 6 does is it sort of says that in any law, any federal law that would apply to this project, anywhere where there was an opinion that had to be formed or a determination that had to be made, whether that's going to be in favor or not of the project, we're going to deem all of them as being done in favor of the project, right? So, and so there are, examples in the Impact Assessment Act, examples in the Canada Energy Regulator Act, where there's a moment where a recommendation has to be made or a determination has to be made, and we are saying, the Act essentially says those are all done in the positive now. It does not, though, importantly, it does not exempt proponents from taking the measures that they would normally be required to meet the applicable approvals or authorizations. So it's saying, yes, you will get your yes, but you still have to do the work, right? So if it is an impact assessment, a major project that's a designated project on the IAA regulation, then you still have to do the work to submit and work through that process. If it's a Fisheries Act authorization for HAD, harmful alteration or disruption or destruction of fish habitat, you still have to submit your authorization application to DFO, and same with SARA and on, right? So, and in that context, we still expect proponents to be engaging with Indigenous nations and plan mitigation measures. Next slide.
Did it not switch slides there?
Yeah, sorry. Yeah, next slide. Sorry.
Oh.
Sorry. No, back to that last one. Sorry. No, yeah, this one. That's right. Sorry. Yeah, go ahead. One more.
Sorry, which direction?
Yeah, there you go. You're good. I knew this was going to be a problem. So in addition to having that determination being made in advance, the early green light, there's something else interesting that this Section 7 of the Building Canada Act does. And it says, not only are you deemed to, when you get this final authorization out of this act, So if normally your project would have required a decision statement under the Impact Assessment Act and a Section 35 Fisheries Act authorization, and let's say maybe a SARA permit, I don't know those, but let's just say that, or maybe a Canada Navigable Waters permit. Here, you're just going to get one. You're going to get one authorization, but it's going to stand in. It is deemed to cover all of those other authorizations that you would have required. So that's useful and that's good. In a sense, we can say, oh, it's good to have just one piece of paper that's going to cover off all the conditions and terms. But then it does another thing. And so then Section 7 goes on to say that we have also deeming this authorization as meeting all the requirements of all those other acts. And that's really important because, environmental laws are both inward and outward facing, right? So environmental laws apply to proponents and they restrict proponents from doing certain things. But they also work on governments, right? We've restrained governments, or we try to constrain them from doing things if they don't follow certain guideposts, right? So even though, like under the Fisheries Act, for instance, there's no real limit to the amount of fish habitat that the minister can authorize the destruction of. But before the minister does that, he has to consider the cumulative impacts, for instance, of the project. He has to consider offsets. There's a series of considerations he or she has to make. Same with SARA, right? It's not that no permits are allowed under the Species at Risk Act, but there are certain constraints that require, the minister to follow before they get to the point where they issue a permit. And under the Impact Assessment Act, it's the same thing, right? We have references to applying the precautionary approach or scientific integrity. And so what this provision seems to do is sort of say, regardless of whether or not those things actually have been followed, and regardless of whether or not those factors have actually been considered, we're going to deem them as having been considered and followed. And so that'll be an interesting thing. On its face, it would seem to preclude most of the kind of challenges to these projects in terms of litigation that we're used to seeing, arguments that the government didn't follow a precautionary approach or that a project didn't consider cumulative impacts. And so those kind of challenges would seem to be essentially negated by this provision. And so we'll have to see how that plays out. There's sometimes some uncertainty about how far Parliament can go with deeming, but that seems to be the plan here. To be clear, of course, deeming can't work in relation to constitutional rights. There can be no deeming that, for instance, Indigenous rights or that the duty to consult has been met if it hasn't been, right? So that is a hard limit there. And so we would still expect, to the extent that there are concerns about consultation and accommodation, that kind of litigation, those kind of legal challenges would still be fair game. Next slide. So yeah, I won't spend too much time talking about this, but in a sense, everything I've just described is a pretty radical departure already from the status quo. But the government couldn't help itself, and so it actually introduced this provision, which essentially allows it through regulation to change essentially any law in the federal statute book. Essentially, is how it was. Certainly, when it was first drafted and introduced, that's how broad it was. Essentially, it meant all they had to do is put a law on the schedule, and if it was on the schedule, they could do whatever they want through cabinet regulation making. Right. So, the reference here to the king, of course, is this idea that that used to be that there used to be a time when kings made all laws, but over time, right, like the whole democracy project and the idea that parliaments are democratically accountable and they pass laws. And so the idea here that cabinet could be, become suddenly more has a greater authority, frankly, over the federal statute book than parliament does, is really quite a large departure from the status quo and kind of a rearranging of our understanding of like the different branches of government and what they're supposed to do. Like generally speaking, governments implement laws. They're not supposed to be rewriting them, sort of like in the black box of cabinet secrecy. So again, it was watered down a bit on amendments. We've constrained this provision a little bit. There are certain laws that are not available to cabinet to change through regulation. But there still are a lot that are, and certainly all the major federal environmental laws are still there. So it's an extraordinary power to rewrite essentially laws passed duly in Parliament through the cabinet process. So we'll have to watch if that actually plays out. And then I think the last slide, Chris. And so, yeah, and so I mentioned, right, so there's this tension between the cabinet and it wanting to have like all this executive power. But of course, we are in a minority parliament situation. And so in third reading in the Standing Committee, Transportation Committee, there were amendments moved and a lot of them passed. And it's hard to know. Actually, I went into the Hansard, and you can't actually tell who voted for what. But we know that there are now criteria to try to further define national interest. As best as I know, this provision has been ignored by Parliament at this point. We've already talked a little bit about this requirement of consent. What does that mean? Like, when do you have to get consent from province? Is it anytime it touches on provincial jurisdiction, legislative jurisdiction, do you have to get consent? And that's kind of my argument, my position, but I've heard other people take a different view. There's going to be a public registry. So there's, and one way to think about this act is that part of what it does, I mentioned that it makes it very hard, for instance, to challenge. It might make it hard to challenge some of these authorizations if you were wanting to, for instance, let's say you're an environmental group or some other group and you want to challenge one of these authorizations. Most of your bread and butter conventional arguments would be really hard to make. And partly because of those deeming provisions. And so then what the act does instead, though, is it seems to shift that accountability into Parliament. So there's going to be this registry. And if you look at the second last bullet there, this idea of the information that has to be made available prior to a deeming of authorizations, there's a ton of paperwork that has to be done. Basically, like if a project finally gets listed as a project of national interest and it gets a special authorization, then basically the NPO has to sit down and write a long report that explains how the process and the substance that this designated project of national interest, or PONI, how the substance of its terms, of its conditions, and how the process that it received are different from what it would have normally received. And all of that has to be published and reported and brought before Parliament. So you can sort of see, I think an argument can be made that what we've really done is we're shifting accountabilities for these projects and for their terms and conditions out of the courts and into Parliament. And again, whether that's a good idea or a bad idea, we can have a conversation about. Lots of sort of oversight, other types of oversight built into the process through the committee stage at third reading. So I think that's it for me.
Great, thanks, Martin. And I think I might have done this last time I facilitated one of these talks for our group, in that I missed something at the start. And I realized that I missed the introductions as I was skipping through slides. Martin, you gave a brief intro of yourself, but and Sharon and Thomas, do you guys want me to provide that brief little bio, or would you guys like to introduce yourselves?
I'm happy to introduce myself when
Okay.
I speak.
All right. Well, I'm going to shift it to Sharon. Thanks, Martin, for that context.
Okay. Before I sort of just touch on the provincial aspects, and I agree largely with what Martin has said, and just want to underscore the point that, to date, no PONI has been designated. But that doesn't mean the MPO, in my view, is not actually assisting to unstick some of the issues with some of the projects that have been referred to it. And that referral, as Martin noted, is a concierge service. There are a whole swath of non-permitting related items that are at issue that I think the MPO is probably charged with trying to facilitate an outcome for. I'm just going to spend about 5-6 minutes speaking to the Infrastructure Projects Act, the BC one. I wasn't going to touch on really the Ontario piece because judging from the audience is mostly Western Canada. As for an introduction, Sharon Singh with McMillan. I'm a lawyer, and that's probably all you really need to know about me. In terms of BC's answer to the Building Canada Act, we have several pieces of legislation, but I'll mostly focus on the Infrastructure Projects Act. That's because the other relevant legislation, I'm conflicted in really saying too much. I'm on the board of the BC Energy Regulator. So the Infrastructure Projects Act, Bill 15, essentially provides for tools that can be used to move projects forward faster. That's at least what has been stated by government. This also includes an expedited EA process provincially. And the way it's structured is you really have two categories of projects. You have category one, which are really government projects that are so designated by the Minister of Infrastructure, and category two, which includes private projects that have been deemed provincially significant, so the provincial equivalent of a PONI project. There are certain eligibility requirements for each of these categories and thresholds for provincially significant projects to be met. That's currently subject to public engagement, and there are certain proposed criteria that have been put out by the ministry, and I can get into that in the Q&A if you'd like, more so than here. But what we do know from at least the minister in the House or in the legislature is that, in her view, the project of provincial significance must have First Nations support and provide for significant social, economic, environmental, and other benefits. She has also said that, again, how that is assessed is obviously going to be more of a policy and political decision, but nonetheless, that's really the broad brush criteria that she's put out there. She's also stated that it is their intention to exclude pipelines, LNG facilities, and overdose prevention sites from those sites. So again, noting that it's both the projects we would typically see in the sphere of private proponents, i.e. LNG, and the public sector in terms of those overdose prevention sites, etc. In terms of the tools, there's many, but in large part, one of the tools is gives the Minister of Infrastructure the power to regulate, to require regulators to prioritize the designated project review. So it's, again, that concierge service with the added tool of the imposition of timelines, as well as recommendations for prescribed actions. Now, how that will actually play out in terms of how statutory decision makers will be respected in terms of how they view those projects, it remains to be seen. The expedited EA lines up pretty nicely, in my view, with the 5-year review of the EA process. That is currently underway, and EAO is engaging on both early phase, the 5-year review of the EA, as well as what this expedited EA process will look like. What we do know is that there are certain exemptions, such as some of the early engagement requirements that were built into the EA process, that will be essentially exempt from this new expedited EA process. There is also the fact that once a proponent receives an EA, the Minister of Infrastructure may order that all other statutory approvals required, all other statutory approvals be issued within a specific time and subject to certain conditions. Now, I think that would work where the EAs, the other ministries are deeply involved in the process, where they have had utilized the EA process to address some of the other issues. And we often already see that in terms of that duplication that exists. And frankly, the conflict that often it raises as to why proponents have to go through both the EA process and subsequently certain permits, when we've addressed both during the EA process, because that's how the ministries are now utilizing the EA process. But nonetheless, it provides for that streamlining to occur. But I still see, and I note Martin's comments around some concerns there that would be raised by those seeking to hold both proponents and governments accountable to uphold environmental and other rights. In terms of what's really gotten the municipalities really worked up, apart from the Heritage Conservation Act amendments, it was the tool that allowed the province to exempt or modify municipal planning statutes after having a little bit of a tete-a-tete with the municipality saying, will you do this? They'll say, no, we won't do this. Then the heavy hammer of the province presumably come in and remove that constraint. There's also something which is a bit of a carryover from the Significant Project Streamlining Act, which was repealed as a result of this Infrastructure Projects Act. And in that legislation, essentially, it provided for, and which was never used, the removal of constraints after it went through a process through cabinet. And this act carries that forward into this legislation, but with some amendments. And so essentially, what it does is if there's a measure that would impede or otherwise interfere with the completion of the designated project, that it provides for the authority to seek that removal of that impediment. But that impediment can't be Indigenous engagement or consultation. And so that is quite a significant power. Like I said, it's something that existed prior to the legislation being brought in. But it has been carried through. There's also something I'm really super excited by, but has not been really talked about that much, which is the QP use of qualified professionals approvals, and essentially looking at some of the low risk permits that are often required as part for these permits. And this is part of, I would say, wider government efforts to really look at how they utilize qualified professionals. It allows for QPs to certify that standards have been met with respect to certain permits, low risk permits, prior to them being issued. And maybe I'll just end, because I know I'm supposed to only talk for 5 minutes, to note that, you know, in BC, you had the Significant Project Streamlining Act. You still have the Environmental and Land Use Act, which provide cabinet with significant powers, that essentially, you know, even if the Infrastructure Project Act didn't exist, you could probably get there through the combination of both the powers already within the SPSA, ILUA, as well as the current Environmental Assessment Act, which through regulation allows for exemptions of both projects as well as sections of the project. And so there are certain enabling tools, but in my view, nothing really new from what, if you didn't piece together certain other pieces of legislation, you couldn't got to. I'll pause there, Chris, and then pass it on to Thomas.
Thanks, Sharon. Yeah, lawyer in Vancouver with McMillan Law. And next we've got Thomas Joe. Oops, I went up. Oh, there we go. Thomas Joe from the Impact Assessment Agency of Canada in Winnipeg.
Thank you, Chris. Yes, Thomas Joe, Director of Indigenous Policy at the agency, currently coming to you from Treaty 1 territory in Winnipeg. So nice to be on here today. I'm going to take it in a little bit of a different direction today. Yes, there was a lot of conversation and I would say a lot of media attention, obviously on Bill C5. But what was also committed to was regulatory approvals for all regulatory approvals to be done in 2 years. So that's something that us at the agency, we're also looking to figure out, as are other departments as well, is what does that look like? What does that look like for us internally? How do we organize ourselves? One, internally as an agency or another department. How do we organize ourselves as a federal family to do that as well, to further, support that objective? What we've also looked at is, what does this mean for proponents, and most importantly, what does this mean for Indigenous groups? So as we start to, move through this, where this is a work in progress, it was quite recent commitment. We looked at, what has enabled projects, what we call durable or efficient, or to move through the process quicker. What are some of the things that could facilitate that? And often we always come back to, and we even sometimes sound like a broken record on this, is sufficient Indigenous participation, especially in the early stages. Now we didn't want to come up with all the answers to this on our own. We do, there is literature out there, both from industry as well as First Nation organizations that highlight this as well. And we also kind of see this in our own work. I know, Mining Associate Canada, they have their Towards Sustainable Mining, which also lists, how their members can establish relationships with Indigenous groups at the onset to help, create a durable project or to facilitate consent. The First Nations Major Project Coalition puts out some great literature on, how Indigenous participation can add value to the process or to a project as well as a process. So there is a lot of conversations on this in this space, and we are also looking at this as we move toward, what does regulatory approval in 2 years look like from our perspective? We just recently published guidance of this in July on our website, which again talks about early engagement between the proponent and Indigenous groups prior to much earlier than when we hear about the project through an initial project description. So why does this matter? And we can't take credit for all this. Like I said, there's a lot of other organizations that have come to this conclusion as well, but we do see it. Is when this early engagement happens, regardless of regulatory regime, regardless of legislation, etc., is one, it builds trust, but it also gets us ahead of some key issues identification, and resolution. And we do see that when this type of early engagement is done on behalf of the proponent, and Indigenous groups are brought in very early to help identify some key issues. Perhaps it changes the design of the project. Some mitigation measures are identified early. That this can, one, it creates a bit more of a partnership model, and in some cases there is a true economic partnership. But what it does is it gets us we come out of the gate a bit more ready when that preliminary work, those relationships have been established, and there is a process to one, identify some initial concerns and to address and mitigate them before the assessment begins. And this is a concept that, like I said, regardless of regulatory regime, regardless of what we're talking about today, is crosscuts. And as far as a durable project and as far as an efficient assessment as well, this contributes to that. Okay.
Thanks, Thomas.
I talked a lot for one slide. I got a lot in there.
No, that was great. Okay, so a few of us ahead of time put some thought into some questions. I see there's a few questions in the Q&A. Maybe what I'll do is I'll pop up these discussion questions, and you guys, our three panelists, may not even need them. They may help. We'll give a bit of time to that, but we'll certainly sort of cut off to make sure we get to some of these questions that have been typed in. So I'll just read out those questions. What is the process for the public interest decision making that the cabinet's doing? And you guys spoke a bit to that. But I guess the bigger question is, will the public interest be served? And that's more of an opinion that'd be great for the three of you to respond to. And then what's the role of impact assessment? I think Martin or one of you said, well, that happens after. But some people conceive of impact assessment as the public interest decision-making process, not just something to figure out how to mitigate afterwards. So that might be something to talk about. Consultation. What does it look like before and after? Is there sufficient funding, time, staffing, and all that, resourcing? And then number 4, again, a bit of an opinion piece. How will or won't Indigenous rights and interests be protected and furthered? And then, of course, will new process be efficient and more effective? So I'll leave those up. But I'll turn it over to the three panelists, and maybe organically you guys might have some things to say.
I think we will all have something to say, Chris.
Go for it, Sharon.
I mean, look, I maybe I'm being too philosophical about this. But in terms of what the public interest is, that's such a subjective term, in my view, and it's loaded with the political sort of connotations there. And so I'm sure that even if we were to have some sort of criteria on what the public interest is, we're all going to disagree on the end result, or we may disagree on the end result. So I kind of look at this as more of a ballot box question in terms of will the public interest be served? Because if you don't agree with the way in which these projects are designated using these very subjective criteria, because getting really granular on them, I think, well, essentially we won't get there. We'll probably take 5 years before the BCA sort of dies out. If you don't agree with it, if, it goes way too far in terms of impacting what the public trust that has been built up through changes to things like SIA, now to the IAA, if it infringes Indigenous rights rather than upholding them, I think you'll see litigation because there's other aspects within our constitutional framework that will kick in, but you'll also see the result of the ballot box. So, I mean, I'm not sure if I'm answering the question, but to me, that public interest determination is such a political, it's a political choice ultimately. So.
Thanks, Sharon. I'm not sure, Thomas, if you can add being a government employee. If so, go for it. Otherwise, Martin, do you have any thoughts there?
Yeah, I'm going to have to dodge on that one. I'll let you leave that up to the other panelists. But if Martin has something to say on that one, I could come back to another question on the list. So I'll pass it on.
I'm sure Martin has something to say on this one.
Well, yeah, I mean, so I think, I think a lot of us are took the view that, frankly, in terms of being able to assess this idea, the Building Canada Act, and related ideas at the provincial level, it really depends on implementation, right? So I think what's clear is that this could go really, there's a wide range here in terms of how aggressively you could use this legislation to move a certain kind of economic agenda forward. And I think it really will come, whether or not I agree that, for instance, like this isn't you won't be able to make that determination based on any individual project. I think it's really going to be a question of how it all plays out. And again, bearing in mind that we're in this funny space where for now, none of this machinery, at least at the federal level, none of it's being used, right? What we have is we have a clear expression at the government, at the federal level, that we need to do more, right? That we are facing an unprecedented sort of like change in our trade relationship with our largest trading partner. That things in the rest of the world are also a little bit more, let's say, dicey than maybe folks had thought in even a decade ago. And so I think if this government can thread the needle and apply this legislation in a way that really does move forward projects that for which there is broad-based support, for which there is Indigenous support, for which like execution is feasible, they will actually get over the finish line if they can pick those right projects. Then and again, the extent to which they need to rely on this legislation, I think, is an open question, and whether it's just a question of sort of like and the work that Thomas just described, right? Like, I mean, if the agency is moving forward on getting on a 2-year sort of track, if DFO and transport, Environment Canada, all of them, if the whole machinery of the federal government starts moving in this direction, and maybe that was just like the part of my language, but the kick in the ass that everybody needed to sort of like get there. Then I think if we can do it in a good way, then I think that there may be dividends, both in terms of like how we're doing here in Canada, but also for the government. To my mind, the trick though is that there are some competing interests, and so for instance, to do all this heavy lifting, many hands make lighter work, and so it's hard for me to see how we can go down this road without also at the same time sort of making sure that our departments are properly staffed and resourced. And then, of course, the same goes for Indigenous peoples who are being tasked, for dealing with all these projects. So it's we'll have to see. I agree with a lot of what Sharon said, and I think it's really a question of implementation.
Thanks, Martin. Thomas, you wanted to pick up on that, or maybe it was a different question.
Yeah, I would say it's a different question, but if we want to go through the order first, I'll come to number 2. Like, there is still, although there is obviously this legislation and there's a process for that, there is still, the IAA as well as, projects that will still fall under that regime. So, if there is happens to be a project that trips both pieces of legislation, obviously there's some coordination that would be involved. But one thing I do want to address in number 2 is although there is projects that are referred under that legislation, there is still, the regular impact assessment process. Which we are working on, right?
Right. And Claire, who I think is in Winnipeg area, Claire asks if we end up seeing less stringent IA, is there a place for something else like a broader cumulative effects or something else? Claire, you could jump in if you want to ask, maybe signal to, oh yeah, she's raised her hand. Okay, let's give Claire the floor. I think, Jeff, you can give her that chance to speak. Wait a moment here.
I guess, yeah, Claire had a couple questions there that if she can't speak, I can address.
I think she rescinded her second one. Well, she's asking, is there a place for resurgence of cumulative effects assessments to better inform waves of projects? So, I guess she's getting at is there's still a role for impact assessment, but what is that role? If the big issues are dealt with, is it just a permitting process essentially after cabinet's made their decision?
All right. Can you guys hear me?
Yes, we can now.
Oh, hi, Chris. Hi, everyone. Yeah, basically my question was with these major projects, if it is sort of pre-IA or outside of IA, and things are kind of moving forward, and in particular for Indigenous nations, like can they strengthen the IA process through doing cumulative assessments in an area-based kind of way for further projects that may come down the line through this major projects office? How exactly would that work? Or do you see a place for that, basically?
Thanks, Claire.
Maybe I'll jump in quickly just to explain. I mean, so actually, like the Impact Assessment Act still would apply. If a project is a designated project, what happens is that if it's declared to be a project of national interest, then the change that the Building Canada Act makes to the IA process is that it essentially eviscerates the planning phase. And it's not quite clear 100% what's going on, but essentially it's almost like you just get to the point where it's like an automatic, to the extent that the planning phase in the current IA is both a planning but also a screening decision about whether or not an impact assessment is going to be required, then you essentially just like you start at yes, one's going to be required, and we're off to the races. And so then we get into right away, like if a proponent would theoretically, like technically, currently, as everything's written, would still have to file an impact statement. And that impact statement would go to the agency, and the agency would have to deal with it. But the proponent would know, and everybody would know, that the decision about whether or not the project goes is, whether the decision statement is going to say that yes, this project should go forward, it's in a sense already been made. And so, that comes back to this sort of language where the government said the question is no longer whether, but how, right? And so to the extent, though, that these processes are still required, that the proponents are still obligated to submit all the information they would need to, they'd still have to prepare an impact statement. They still have to, the Indigenous consultation is still baked in. There's no way around that. I think the idea is that by focusing on the how, you'll get straight to the meat and potatoes of project effects and mitigation. And you're going to try to do that in sort of like in the context of this sort of like, yeah, like let's keep going. And so then again, and then that process should end. It's interesting, the Building Canada Act itself doesn't actually specify the timeline, but I think, and Thomas can correct me, but I think the assumption is that that 2-year goal would also apply in this space, and he's nodding, so I'm doing well. And then you get your decision statement. And so, but to your question, which I think is great, I think, overall, I think the more that Indigenous nations do in terms of baseline work for themselves, regional assessments, cumulative effects management frameworks, like if you've got that stuff ready when a project comes knocking, then I think that you are in that much more of a stronger position to sort of say, well, actually, we've already done this work, and this is how this fits in our traditional territory. That's a space that hasn't been totally fleshed out yet. But I think that bearing in mind that time here is at a premium, for sure, the more work that's done at the outset, I think there's going to be a strong sort of like bias towards favoring that kind of context, because then you can just keep running.
And maybe I'll just add, the cumulative effects, albeit you might have criticism of it in terms of how it's incorporated within the IA. It is. And I think the rub will be, again, the timelines front. And so how do you manage to do a comprehensive cumulative effects assessment or land use planning or whatever it is that, you may want to incorporate as a nation, more of a regional basis, when it's within a pony process. And so I think that's going to be the rub. It's not so much whether you can do it, whether the act enables it, the act does. It's whether you can do so within the timelines that may be imposed upon you.
Thanks, Sharon. I see we've got a couple questions that I put up about consultation, Indigenous rights and interests, and we've got a few questions in the chat there about, what's the legal standard for consultation? Is it FPIC by UNDRIP or what? A question was for Thomas. How's it possible to have a consent before sessions begin? Does that circumvent FPIC? Do you guys have any thoughts on, and maybe you can start with Thomas, how to navigate all that?
Yeah, I'll jump in. And I think part of that question might have been part of the talk about consent before, early in the process might have stemmed from when I was speaking to some of that early engagement and having Indigenous groups supporting the project from the onset. And a lot of that was more, imparting on the proponent through some of our guidance that, a lot of that early engagement, that relationship building at the forefront, on whatever measures are put in place to build that support for the project. And obviously there is the process that we would have through the assessment as well. And, there is some timely legal cases on this right now. that talk about this very issue, right? The Quebec decision does speak about, FPIC, what it is and what it isn't. Obviously, that is being appealed as well. But when we look at it, if you look at the decision the way it is right now, it is the right to a robust process, not a veto, but it is a right to a robust process. And that's something that obviously we're looking at, other departments are looking at, but how does that fit into the process? One thing we are looking at, and I know the question is specific to what does consultation look like before or after a designation. I can't speak for the projects of national interest, but I can speak to what we're considering as we look at our process, and making it work within a 2-year time frame, is we recognize that although, we have this guidance on, proponents, you got to get there early, you got to do this. There's also a recognition that we also need to probably step up our game a little bit. We need to get out early. We need to get out and have those conversations early with Indigenous groups as well. And not just us, as well as, some of our permitting authorities, to have those conversations, because, one part of EPIC is prior and informed, right? So everyone needs to look at how we begin the process, getting out as early as possible, even if there is incomplete information. But one thing we also are recognizing that if we are looking at, doing consultation in a shorter time frame than we usually do, then we need to avoid kind of that time lost or that lag time where we're doing stuff behind the scenes and Indigenous group doesn't hear from us for months, right? Then we lose that time, we lose that momentum, and then we kind of create a bit of a disjointed process. So what could it look like? And again, I'm not speaking for project national interest, but for a 2-year process that we are still working on, is we're going to have to be out early. Conversations going to be continuous, and we're also going to have to maintain the relationship post any decision. If we are going to continue along with this time frame.
Thanks, Martin or Sharon. Did you want to add to that? Otherwise,
I think in terms of, the UNDRIP standard, so to speak, and the impact on, or even on UNDRIPA and DRIPA, and the impact on the Crown in terms of the level of consultation it's going to require, as Thomas noted, that's subject to appeal both in BC and as well as for Quebec federally. So, currently as it stands, as I view it, it's a right to a process. It doesn't guarantee that an indication of consent or opposition will lead to the project either being, again, not speaking on Pony, but just generally a project proceeding or not proceeding. It has to be considered in good faith with a view of upholding both the honor of the Crown and looking at UNDRIP as a whole rather than in just one article or two, and seeing if you meet that. And so I don't think articulation of it as a veto is correct, or articulation of it as a consent as an indicator of whether a project ought to proceed is in my view is the way the both levels, or all levels of government, frankly, are looking at it.
Thanks. Yeah, I see that there was a question from Deborah Stokes. Will infringement of Indigenous rights be justified? Has case law not indicated that infringement is justified if it's deemed in national interest? Okay.
That was an excellent question, by the way, Deborah, because I looked at it. In my view, I think it'd be to the extent that it results in infringements on rights. I would think that the process and the articulation of why it was approved would be a part of the justification, supporting any such infringement.
Maybe I will, unless Martin, you want to jump in, I will, is that a yes? I see you put your mic on.
No, I think it's just, we're talking about, these are very reasonable hypotheticals to be thinking about. Again, it comes down to how, I think this government at least is not intending on using this legislation in a way that would lead to that kind of litigation, but it certainly could be used in that way. And certainly there is, established judicial sort of the doctrine suggests that, resource development can be used to justify infringements. And so that I think that really that hypothetical really animates a lot of the Indigenous nation concern around this legislation.
Thanks. So I think what I'll do is I'll try and get through one or two more questions, and then I'll turn it back to each three of you to just maybe you can just provide some wrap up or bigger picture thoughts on what this all means and going forward. We've got an anonymous attendee just talking about qualified professionals and how to make sure that if things are going to be shifted more to that permitting model is what I'm calling it, or QP reliance model, how to make sure it's robust and credible. And I think Eileen Miranda in Vancouver, if I recall, she is sort of asking the same sort of, her question is gone. But again, I guess it was looking at the robustness of this process if that public interest piece is taken away.
And again, this is subject to in BC, subject to ongoing engagement at this moment. So I encourage you to actually go through engage.gov.bc, I think, or .ca, something like that, and input into it. From my engagements to date, what the government is looking at is both the types of permits, one, so looking at what would actually qualify or be eligible to be subject to such a QP authorization. And then the second part of that is the requirements in itself to be QPs and the standards. There is also auditing and other QA components that the government is considering. But these are real live issues. I mean, the province swung quite hard after Mount Poly, and I'm sure nobody wants to repeat any criticisms of the same thereafter. So that is, I think, great questions and great considerations. All I know is that those are live considerations and live discussions amongst at least the industry, as well as the QPs that I've been at the table with.
All right, thank you. How about Thomas? Do you have any final thoughts you want to leave the group with? We've got 3 minutes.
Yeah, I'll just say, regardless of, regulatory regime, process, etc., we have our constitutional obligations specifically to Indigenous people. We also have our commitments under the UN Declaration Act. So those are still in play. So that is why we, when I talk about, the work that we need to do as we move towards a 2-year process to, design something that is consistent with all that. It is also something that when we have those conversations with proponents, that we highlight the importance of that, that early relationship building. I remember when I started in the federal government, and I had a manager from Norway House Cree Nation, and she told me it's all about relationships, this job. And that was specific to working with Indigenous people. So in that regard, it's if I have to leave everyone with something, it is about the relationships between the proponent and the Indigenous group, as well as a relationship with Canada and Indigenous groups as well. And that is how we, can meet our obligations, our constitutional obligations, as well as our commitments under UND.
Thanks. And we'll get back to you, Sharon, for your final words. And Martin, do you have any final words?
Yeah, I mean, I think I think that, again, bearing in mind what we're seeing, that for the most part right now, what we're seeing is a government that has simply swung the door open to proponents, I think, to say, like, we're interested in building and we want to build, and we're prepared to sort of like create this office that's going to provide that kind of concierge service, and then maybe like to some of Thomas's points, like, and at the same time, I think there's been a general message throughout the sort of federal family that we need to move on these things. We need to move faster. If that's all that comes from all of this, then great. Like, I think that's and that's great and positive. And I think in part, the debate that brought us here wasn't necessarily grounded in facts. It was very much about vibes. This idea that somehow regulation was inhibiting all of this development. Well, so to that extent, we've addressed the vibes. And if it was all about vibes, then good on everybody, and we can get on with it. And so then we're just gonna have to see what do we do with Bill C5 or Building Canada Act. What is it? Does it end up doing any heavy lifting or not? It's hard to say right now. There are more and more projects are being referred to the MPO. So, presumably at some point, someone's going to say, okay, let's go. And so that will be the interesting thing to see which project gets itself there. And then within that space, which of these powers are used and how aggressively they're used. So it's sort of wait and see. And so I guess for the people who are working in a real practical way, nothing has changed on the ground in terms of like the laws and regulations, but you have a very receptive federal government now that wants to work with you to push these projects forward.
Thanks, and Sharon, we'll give the last word to you.
Try to do it in a minute. I think vibeflation is a real thing, as our former finance minister said, Martin, so don't knock it. Largely agree with everything Martin said. There's I think several things at play. One is the signal to the public service around its risk tolerance. There is a general belief that the risk tolerance was too low. And so getting that scaled back to a more, I would say, balanced level is probably a good thing. I agree that, there is a lot that has been, frankly, unjustifiably so put on IAC as being the blocker of projects. I don't agree with that. I think there is redundancy and duplication, yes, but there were tweaks and are tweaks that are necessary in terms of scoping, as well as the level of engagement with certain nations that was required to be completed. I think the IAC is looking at that quite robustly, as well as the others. And so, I think some of the good work that's been done, I hope that's not removed, because there's been a lot of public trust that's been built into both the EAA locally here, as well as IA. And so that's one piece. And in terms of, the Building Canada Act and everything else, I predict, if you want a prediction, it's going to be but a handful, maybe not even a handful, one hand projects that are actually going to go through that process. I think the government has been very, this is now a political commentary rather than anything, very careful in picking those projects to date that is referred, that have largely gone through the process already in terms of large scale permitting, has Indigenous support, First Nations support, Métis support, not maybe universal, but predominantly so. And I think it behooves them to continue to think that way. And so because I think it's going to be a very rare couple of projects that really want to see themselves on the pony list, because once they get on there, that's a big ass target on their back, and nobody wants that. Maybe the ass part I could have left out, but there you go.
Thanks so much for our three speakers. Martin Olszynski, University of Calgary; Sharon Singh, McMillan Law; Thomas Joe, Impact Assessment Agency in Canada. Thanks everyone for joining. It looks like we should have run this for an hour and a half. We debated it because I still see there's 71 participants and we're a couple minutes after the time. If anyone
reach out to any of us, I'm sure. So
if any of the membership has topics that they want to be covered, if there's anyone that wants to speak, we are open as a board to entertaining these things. It seems to be valuable to our membership to have put on these talks. And so please do reach out to us. And with that, unless Jeff, you want to say anything further?
Nope. Just thanks very much, everybody.
Thanks, everyone. Have a great day.
Thank you. Bye-bye.
Bye.
And thanks, our speakers.